That, Malas, has grave consequences. I have no problem, however, so much time my learned friend wants to look into it. The matter is coming tomorrow before the criminal court.
Tomorrow?
Yes. And I'll tell you, the whole conspectus, I've not even opened yet. My learned friend is Malas, copy or no copy. I think our extra generosity in giving him a copy does not become a ground for adjournment as far as the governor is concerned. We may not have served him a copy, we served him a copy. That doesn't mean he has a right to adjournment. Now, let me explain to Lordship what the issues
I
are.
never claimed it as a right.
No, that's all right. I'm not saying you have, but allow me to open. Your preemption is what I'm trying to preempt.
Yes.
Preemption is what I'm trying to prevent.
I may make one request before the learned senior counsel. I appear for the fifth respondent. We have entered KV.
It's all right.
That's all right.
We've
Everybody's
also been served a copy just in the morning. But
No, if the matter is tomorrow before the concerned court,
no, we have not initiated any proceedings. That much I can
you
say.
have not initiated.
We have not initiated. We have
Then
lodged a complaint before the Superintendent of Police Lokaयुक्त. But for that, no other proceedings.
All right.
But our instance is there.
let the senior counsel
Yes.
say something. Yes.
Let me just itemize. I'll try to be as brief, but
Yes.
still it will take a little bit of time, not too much. Not too much. There's one of the old Parkinson's law that work expands to fill the time available to do it. Just because the Lordship happens to be freer on this afternoon, I'm not going to expand the work to fill the afternoon bills. That's not the intention.
On the lighter side, my lord, in the courts, the work expands to fill the, my lord, memo, which we ultimately sent, my lord.
Now, Malas,
Yes, sir.
there are serious constitutional issues. There are direct statutory issues.
Yes.
I'll just itemize them and then Malas deal with one by one, probably with the simpler statutory ones first. And then Malas just itemize also the constitutional ones. Malas, the matter raises far-reaching issues for the reason, number one, I'm only giving the issues, so I should see the. Malas, you have an elected government. The elected government has the mandate of the people. Anybody, I'm not saying these are those people. I'm not saying about them. I'm saying in theory, in jurisprudence, anybody on the street comes with a complaint. That complaint, Malas, is made decades and decades, let us say, assume, after Malas an incident. A, inverted commas, friendly governor gives sanction. Before that friendly governor gives sanction, the government of the state, scrupulously taking away the chief executive of that state against whom the complaint is made. It is not a case where I, Malas, have a cabinet meeting where agenda item 1 I recuse and agenda item 2, 3, 4 I come in again. He doesn't attend the meeting at all. The cabinet collectively takes a decision, and that order is worth seeing, not in length alone. Every possible legal and factual aspect is dealt with in 100 pages, saying these are the reasons why this complaint is false, frivolous, vexatious, should not sanction, cannot and could not be granted in law by citing case law, etc. This is done after Malas, a purported show cause notice is issued by Malas, the governor, on events ranging from 1992 to 2022. From
1992?
1992
1992.
to 2022. I'll just, fellows, I'm only oralizing. I'll tell you a very shocking situation. The governor receives that 100-page order, if I may say so, or a decision of the cabinet. Clearly, he is bound because the cabinet decision binds him and it falls under no part of the accepted category of 163. The governor, in a short 2-page order, which is the impugned document, decides to decide only one point. Does not address any single reason why the sanction ought to be granted on the merits. Not a single word of the 100-page order. Namely, Malas, suppose the cabinet says sanction can't be granted for reason 1 to 50. You can say reason 1 is wrong because of so-and-so, reason 5 is wrong, reason 10, not every ground, but at least most of the grounds. He does not address a single ground. The only ground he addresses is that there is conflict of interest and gives a one para en masse blanket order saying the cabinet is the alter ego of the chief minister who's the accused. Not the accused yet, Malas, but the potential accused. That's all. So, Malas, the cabinet, Malas, on even a doctrine of necessity, cannot act after the chief minister does not come into the meeting on the day at all. There is a single agenda meeting and he's not present at all. He decides that alone. Now, assume you decide that. What you have decided is that the cabinet decision is not binding on me. That's what the governor is deciding, Malas. I hope I'm clear.
Yes.
He is not deciding why.
Oh, is that the observation in the order?
Yes.
Right.
I'm sorry. Back to this case for the last 5 paras. Only the 1 para was off the case.
Yes.
These 5 paras on the case.
Yes.
Whatever I've said in the last 5 minutes is what the governor does in the order. He doesn't decide a single factual or legal issue. He decides one issue that he is not bound by the advice of the cabinet because according to him, the cabinet is the alter ego of the chief minister, even though the chief minister did not come to the meeting at all. He then picks out this complaint out of at least 15 or 12 pending for some length of time, which he has not decided, not sanctioned, not dealt with, and grant sanction in this one, without a single reason as to why sanction ought to be given, notwithstanding the cogent 20 reasons given by the cabinet decision. So cabinet is not binding, let me assume, in favor of the impugned order, if I may call it the impugned order. If the cabinet is not binding, you have to give reasons 1, 2, 3, 4 why the reasons sent by the cabinet are bad. Then we'll see. He doesn't give that. On that short ground, the order is bad. That is one part. The larger issue, of course, is that if you accept this principle, and your Lordship has fortunately in several Supreme Court and Karnataka High Court judgments not accepted it, saying the sanction is a serious matter, it is not casual, it is fully reviewable. But if you accept the principle the way it is activated, anybody here will file a complaint to me. I'm the governor, and I have to have only some inclination. I call him a friendly governor. And he will then issue sanction, followed immediately by a clamor for removal and resignation of the chief minister, thereby nullifying the popular mandate. You don't need 356, fellas. You don't need any provision of the constitution. You don't need 163 to destabilize governments like this. Is a larger issue. Third issue. So first and main issue is he has not decided on that ground alone. He has not given a single reason why sanction, apart from saying I'm not bound by the cabinet. Second reason is the larger federal issue. The third reasons are narrower, but I'll come to them first when I deal with detail. He grants a 17A purported approval. Purported. Now, Your Lordship, I'll come to them one by one. I'm not.
Yes.
There are at least 2 conditions precedent to a 17A, which are on the face of it missing here. At least 2, if not more. Condition precedent 1 is that it has to be on an application of an investigating agency. Lordship will call him policeman. That is written in the section itself. I don't have to carry scroll to Dhanbad. The second condition is that provided this is a police officer who complains, he then complains in respect of a decision taken or recommendation made by the public servant, namely the chief minister in this case. The chief minister, it is common ground, has taken no decision, made no recommendation, not once. He has never touched the file.
No role? No role of the chief minister?
No role, no file noting, no recommendation, no decision, the matter never came to him. This happened mostly in other governments. 92 to 22. The allegation is that he's a beneficiary. The allegation is not that he's a decision maker. Now, 17A condition on that short second ground, there must be a stay. At the moment of condition precedent. 17A, you pick up and read the text. Has a police officer applied to the governor? My learned friends have not yet donned the police uniform. The complainants here. They are private complainants. Second, can it be a complaint about show the decision to the court? Which is the decision taken by CM which you are assailing? Which is the recommendation made by him? This is that kind of category where Lordship knows 17A was made for when I write on the file some recommendation. And that goes through. There is nothing. That's point number 3, Point number 4 is also the new Sanhita, the section 218 of the Sanhita.
197.
Yes, which is the equivalent of our equivalent of our 197.
Yes.
Now, here there's another interesting mix-up completely. Also 197, also section 19 of the PC Act. Similar situations. The mix-up is simply this, that you apply in your order 218, but 218 must mandatorily, the Lordship has done enough, 197 cases, involve the nature of the offense and a specific offense. It has to say that this man has committed this offense qua him, namely section XYZ, the ingredients of which offense are these. And in this manner, the ingredient is satisfied.
All in discharge of official duty.
And most important, I'm very grateful, in discharge of official duty. Nothing. And these are admitted positions. That's the third ground your Lordship must stay this completely laconic, unreasoned order with no application of mind. The fourth reason, is natural justice. The show cause comes to me, referring, it is preceded by the Advocate General's opinion also. There is one separate, small, short opinion also by the Advocate General. But forget that. The show cause, which is 26 July 24, comes to me referring to only one of these complainants, Mr. Abraham, who is respondent number 3. The entire show cause is about one Mr. Abraham, respondent number 3. The final order passed by him after he receives the 100-page order of the cabinet is a 2-page order, final order that I'm not bound. In that, he dismisses the cabinet, grants sanction by adding a paragraph about the other 2 complainants about whom he has never show caused me. That's point number 5. He has never show caused me about Mr. 4 and 5 who are sitting here. Yet the impugned order relies upon, refers to for the first time about and to Mr. 4 and 5. And Malads, the still larger issue which you should need not go into today is Malads Nabam Rebia, which says that you must, it gives Malads actually the operative para of Nabam Rebia is really sufficient. It's a constitution bench. It says they are the only 5 cases in which the governor can act without the aid and advice. It consolidates the law in that 155 para number. This clearly, I would say, admittedly doesn't fall under that. To which my learned friends rely upon a judgment of MP 20 years earlier, Madhya Pradesh police establishment case, which suggests that though 163 binds the governor, there may be other cases where there's a true conflict of interest. Now, there are 2 answers, 3 simple answers. The answer number 1, Nabam Rebia cites the earlier one and then summarizes. Your Lordship will follow the second one.
Yes.
Second, and even more importantly, Nabam Rebia copiously relies on Shamsher Singh, the 7-judge original judgment, which says presidents and governors are totally bound, in this case by 163 and not beyond. Thirdly, and most importantly, on that debate, the MP establishment, it says that you may have exceptions beyond 163, where there is a case where he sits and becomes his own decision maker. Obviously, I mean, 163 will not say that your Lordship will not sit on a case which affects your Lordship. It would not, it's obvious we'll say there's a bias and a recusal. So that is the MP establishment case. But you cannot in one foul sentence of the pen say that the entire cabinet is superfluous because it is headed by the chief minister and ultimately all the ministers enjoy ministership at the pleasure of the chief minister. That is, then there is no question of any doctrine of necessity, cabinet governance, etc. Now on these, let me go one by one. I've troubled your Lordships enough on oralizing. Let me be more focused now with your Lordship. Let us make it simpler. I'll go with the simpler points first.
Where is the impugned order?
Yes. So I'll go with the simpler points first. First point would be 17A.
No. Where is the order?
No, on the impugned order, 41. I'm taking a Lordship to the impugned order to make the 17A point. 41
Yes.
of the paper book. Though I want to start with 17A, may I just read the order relevant parts just for my Lord's convenience. Decision 42,
42.
Starts at 41, 42.
Yes.
Decision of the competent authority under 17 capital A, my Lord has got there?
Yes.
42. Now I will skip Just note the top para, first line is petition from Abraham. Lordship may put R3 there. And para 2 below adds 2 more names. Just tick that para 02. I hope my Lord has got
Where are the 2? Para 2, yes.
These 2 names are Pradeep Kumar and Sneh Kumari Krishna.
All right.
Now your Lordship will know these are 4 and 5. Complainants 4 and 5. R4 and 5, I'm sorry. Now just note, it is common ground that these 2 names are not in the show cause, which is at page 265. The show cause is 26/7/24. At 265, I can't show a negative. I don't need to show a negative. Admittedly, does not have these 2 names. It's
Volume.
265.
Volume 2.
Volume 2, I'm grateful. I'm grateful. Please say volume 2. Please.
This is dated 26/7/24.
I'm grateful.
Yes.
And the man named is Mr. Abraham R3. Your Lordship can't find a negative because it's not there.
Yes.
The other 2.
Yes.
Now come back to the document Lordship were reading at page 42. This Abraham Malad's complaint, which your Lordship is reading just now at 265. He receives the complaint and the same day issues show cause. My Lord, no single straw breaks the camel's back. Your Lordship takes a holistic view. Your Lordship sees everything in a holistic perspective. Legal malice is not that I will come and say, look, I have legal malice against you. Nobody says that. My Lord infers legal malice by the overall conduct. So I come in, so look at the larger issue of federalism. of elected government or mandate. Anybody goes to a friendly governor, gives the complaint today, the friendly governor issues show cause the same day. And well, 12, I made a separate point on discrimination, Article 14, arbitrariness. 12 major complaints are pending with him, where investigation is complete. But Malas, some blue-eyed boy, as far as this particular complaint is concerned, comes in and he acts on the same day. So how many times the Lordship had a show cause the same day, Malas? There is no time limit for a show cause. He selectively plucks out this on the same day. But well, I'm going ahead of my own story. Let me go one by one. Since the Lordship is on this is a natural justice point on para 2 of page 42. 42 is a natural justice point, para 2.
This is the show cause notice.
No, 265 is the show cause,
Yes.
where only Abraham is there.
Yes.
Whereas the final order has 2 more complaints
That
added.
is the second paragraph.
That's right. Without any show cause to be quay those 2 complaints. I have no idea who the complaints
Now
are.
you said contents of those complaints form a part of this order. Which are those paragraphs?
But this first para 2 itself.
That's it, sir.
That's it.
Yes,
Because
fine.
because my lord is absolutely right. Because he doesn't decide any of the merits. He says, I grant sanction because I am not bound by the cabinet. One line, I'm going to show that in a minute.
Yes.
Give me a minute.
Yes.
1 second. And till date, Palats, you have passed a final order. I have not received these complaints.
Not received the complaints.
This
So-
4 and 5, para 2, which my lord is reading and
So-
holding just now.
The show cause note is only
Abraham, this para 2 complaints, while I am arguing before your lordship, as I stand here, I have not received, which have become part of the order of the Honorable Governor. Now, let's kindly go further. Page 43. 43.
Yes.
43, Malas, can be ignored the top part because he's telling you when I received, etc. Come to para 4. He then notes only descriptively that the government of Karnataka has appointed a high-powered commission also. That is para 4. That has nothing to do with the decision-making process of the governor. No reason. Para 5 quotes the operative part of the resolution of the cabinet. It's a little unfortunate. I'll show one of the most detailed cabinet considerations ever which your lordship can come across.
The operative portion is
That's
quoted.
right. It's a insult to the cabinet to quote this.
It's
Alone.
a very, very detailed, my lord, I wish every state has such a brilliant cabinet which can write